You're watching the Florida Channel, a public service of Florida Legislature, WFSU-TV, and Florida State University.
Good morning and welcome to the Florida Supreme Court and this oral argument session. The first case on our calendar is standard jury instructions in civil cases. Are the parties ready to proceed? And you've already determined how you're going to divide up your time, correct? Okay, who's going to proceed first? And you're going to do 5 minutes and then 5 minutes of rebuttal?
Yes.
All right.
May it please the court. Good morning. My name is Tracy Gun, and I have the pleasure of serving as this court's chair of the Supreme Court Committee on Standard Jury Instructions in Civil Cases. I'd like to take just a few minutes to present the background of this products liability proposal and how it differs from the committee's usual submissions to the court. I have worked with the committee for a number of years, first as the reporter whose job it was to take the minutes of the committee, and in that capacity I reviewed the minutes of the committee for many years before, so I'm very familiar with the work of the committee over a historical period. And I would say that there are two primary ways in which these proposals differ from those that usually come to the court. The first is that the vast majority of this committee's proposals usually come to the court as a unanimous or virtually unanimous consensus position of the committee. There usually is not a majority view and a minority view. There's usually not even a vote taken. There's usually just a discussion until a consensus is reached. And secondly, in most cases, the committee will not propose a new instruction or a change to the instruction unless there is that consensus, and will err on the side of remaining silent and waiting for the law to develop. Here, both those issues are different than usual. We had, for the past several years, 3 different subcommittees working on the entire jury instruction book at the same time. The Book Reorganization Subcommittee, the Errors and Omissions Subcommittee, and the Plain English Subcommittee. The committee submitted, and this court has approved, a wholesale reorganization of the entire rest of the book. But when it came time to do these products liability instructions, both those 3 general committees and the Products Liability Subcommittee identified a number of issues that warranted some further discussion on the substantive issues. And for some of these, the committee was unable to reach a consensus. And after years of debate, literally years, the new discussion of products liability began in 2001. The majority of the membership of the committee called for a vote, and there was a quorum of the committee at attendance at that meeting, and the committee was then bound by that vote. Again, that's not our usual procedure, but the committee at that point agreed that a consensus was not going to be possible. So we had the vote, and we moved forward with working on the rest of the instructions. We took votes on a number of issues as we went along, and several of the votes were not unanimous, but all members of the committee worked together, and once a decision had been made, the rest of the committee worked on the next issue going forward. This is an extremely diligent and hardworking committee with a membership full of experienced lawyers and judges, and there was spirited debate and intense disagreement within the committee on some of these issues. But
is that because the law wasn't seen to be settled on certain issues?
Yes, Your Honor. And
as opposed to just people posturing?
I believe that the people who disagreed with these issues believed in good faith that the law was unsettled. Yes, Your Honor. And a majority of the committee agreed that the law was unsettled on some of these issues.
Were there concerns that in some of these, and we've highlighted certain ones that I guess
yes.
That's going to be discussed, that there might be potentially a deviation from what the law is?
Yes, Your Honor, and there is a concern about that. The proposals as submitted were approved by a majority of the committee. That does not mean that they were unanimous. And the court's issues that you've identified are precisely the issues about which there was debate on those questions.
See, we at least read what you send to us.
See, yeah. I know, even though it's this big, you at least read what we send to you. And virtually everyone on the committee did identify some issues where they were at least concerned, if not convinced, that the instructions either did not accurately reflect the law or at a minimum had made a statement as to what the law was when the law in fact was unclear. And we had a little bit of a chicken and egg problem because these instructions had been around for 20, 30 years. And when we went back to look at them, when these 3 committees were going, fine-tooth comb through the whole book and reviewing citations and reviewing the history of these and reviewing the minutes. And
but Ms. Gunn, let me say, I believe the court really understands what a great job that your committee and the members of your committee have done. And this is in no means intended as criticism of the committee or the individuals, but as we saw these things, I think the members of the court were concerned that we needed to really to sort of flesh these out a little bit further. And again, by no means, I think all of us to a person thank every member of the committee for all the hard work, and we know because they've been kept apprised, as you let the court know. But as we start through these, let's take an overview. There have been certainly a lot of comments. Is it not possible to for this court to make some suggestions based on those comments and ask the committee to consider doing X, Y, or Z?
We would greatly appreciate that, Your Honor.
Okay.
And in
so
fact,
we could clarify then some of the things that we should do.
And in fact, you'll see that the committee frankly reached the point where we were unable to reach a consensus, but everyone agreed that we needed some further guidance from the court.
It appears from looking at this that even if you, Justice Parenti, I think, was concerned because we see at times that sometimes committees, they become philosophically invested rather than invested in the system.
Yes, Your Honor.
And as we look through this, it appears to me that there's a fair cross-section of all different ideologies, if you want to call it that have commented. Do you think that's true?
Yes, Your Honor.
And there's a lot of consistency, for example, on the merging of the strict liability and some of those things together. And it appears that both sides are in agreement that maybe they shouldn't be together. And although the committee may have come to that conclusion, it appears that, like, for example, on the design defects, the proposal number 9, in merging these things together, that both those who do defense work on that issue and those who present those claims are sort of the view that they should not be merged. So could we not, if the court thinks that that's a correct analysis, suggest they be separated and the committee could do that?
Absolutely, Your Honor. And of course, the existing instructions do separate them. A majority of the membership of the committee voted to combine them. That was an issue of great debate within the committee, and there was a very strong minority view opposing it.
Are you going to speak to that? Because that's the first one that raises.
Okay, Your Honor.
Maybe that, in fact, that's the guts of strict liability, and getting it right is critical.
On behalf of the committee, I just don't
understand. I guess I don't understand what the benefit is to merge them when you might have manufacturing and design defects in one case or not. What was, is Mr. Stewart going to speak to that?
Yes, Your Honor. If I could let the commentators address those issues. Just on behalf of the committee, I wanted to be here to kind of provide the background and let the court know where we were. In terms of getting the equal, if you will, view from both sides. We did, of course, working with the court, make an effort to comprise the committee with a balance between both sides, and then also the court giving the additional opportunity for comment, I believe, opened that up.
The committee itself is not recommending any changes to their proposals based on the comments.
The committee has made its proposal. That proposal is based on the majority vote of the committee. We certainly act at the discretion of the court and would welcome any direction from the court on remand.
But the fact of the matter is the committee has not really had an opportunity to consider the comments that have been filed this year because there simply was not time between when those comments were filed and when you were asked to respond to them.
Your Honor, that is correct, but I believe that on the issues that the court has identified in its notice, they were virtually all matters that the committee had previously decided. There were a few new issues, including the new 3rd DCA case, that the committee could consider. The other issue is the change in the composition of the committee. And many of our members rotated off due to term limits, and unfortunately many of those members were our most active members on these issues, and we have an entirely new committee. A third of the committee is new now. So I'll save the rest of my time for the end if the court has any further questions, and then Mr. Stewart will speak to the merits of the issues.
All right, thank you. Mr. Stewart, are you next? Okay.
I am, Your Honor. My name, of course, is Larry Stewart, and I'm here for what has been described as the plaintiff's interest, although this is not, as you're well aware, the normal case where there's a winner and loser below and we're arguing up here as advocates for what the law should be. This committee process depends upon for its integrity, intellectually honest appraisal of what the law is, and not advocacy at the committee level. Our committee meetings are not supposed to be charge conferences.
Let's
cut
take
through
aside,
that and
right.
get to
We
it.
just need to get to
Okay.
403.7. Okay, what's it merges two together. Is that something you all, I couldn't quite, the Florida Justice Association says one thing, someone else says something else. So just give it, I know you try a lot of products liability cases. Is this a better instruction than what has existed in the past? And does it conform to the law?
It conforms to the law in one respect. In another respect, we believe it does not conform to the law. So risk-benefit, we believe, does not conform to the law.
We've never adopted the risk-benefit approach. The court has not.
You have not. It has been discussed in dicta in some decisions, but there has never been a holding adopting risk-benefit. And as a matter of fact, this court adopted West, wrote West, which adopted 402A, which has no risk-benefit in it whatsoever,
but
except as an affirmative.
Anyway, with the merger, is that if you have risk-benefit, that at most pertains to a design defect case. It doesn't pertain to a manufacturing defect case.
It would not pertain to a manufacturing case. That is correct. But we think that it should not be part of 403.7 at all, because risk-benefit really is a negligence test.
So if you take that out and you separate the instructions back, what's different from what existed? I mean, what's wrong with what existed?
The only thing that was wrong with what existed was that it included risk-benefit. Because when we got into it...
No, I'm saying with what existed, you mean in the current instructions?
In PL5, risk-benefit is in PL5. Because what happened, back when this court decided Hill in 1981, there was a footnote in Hill. In Hill, Ford made the argument in the Hill case that there ought to be only a negligence standard for design defect cases. That's the second half of the Hill case. This court rejected it and said that strict liability applies to both manufacturing and design defects. That was a holding in Hill. But in a footnote in Hill in 1981, this court said, committee, we want you to work more on the instructions. At that point, there was no risk-benefit in the instruction whatsoever in PL5. The committee went back and spent an entire year working on it. And they changed the instruction by defining what was the term unreasonably dangerous. But then they got Ford's brief in the Hill case, which was arguing for a risk-benefit test for design defects. And using that brief, they added risk-benefit into PL5.
And when was that adopted?
That was adopted in 1983.
Well, so wait a second. Now, I guess, and I see now where that is. So, really, can you tell, is 403.7 then, other than merging the two, different from PL4 and 5?
It is not. It is the same as PL4 and 5, except that it puts the two together.
Okay, but if we separate them back out, it's identical to what existed.
It would be essentially identical to what we have.
So it seems like you have a hard, since we've had this in, I assume that courts have been instructing on the risk benefits since it's already been in the instructions. When have we ever removed something after being in the instructions for 25 years unless we change the law about it?
Well, adopting an instruction is not a statement from this court about what the law is. Your opinions always say that you are only approving it for publication. You are not approving it as
I guess what I'm asking you is, it seems that if we were to remove it, we'd be making a statement that should have been made at the time we adopted it, which is that's not what the law is. So I'm a little, now that I see it's in PL5, I'm less concerned that it's in there.
Well, the problem with it, there's several problems with it being in PL5. First of all, there's the question of whether it is in fact the law of Florida, whether it ever has been adopted. And I submit, and we've argued this in our papers, that there is no case in Florida that has ever adopted risk-benefit. That's number one. Number two is risk-benefit is an entirely different conceptual theory. It is a negligence theory. And what has happened is you have a negligence theory parked right in the middle of a strict liability instruction. That's the second thing that's wrong with it. The third thing that's wrong is that when the committee adopted this back in 1983, it specifically said in the notes, we're not saying whether it's right or wrong. We're not saying how the trial court should decide which to give, and we express no opinion about that whatsoever. So there's no guidance whatsoever for trial courts to decide in any given case whether they give consumer expectation test or whether they give a risk-benefit test. So we end up with courts, trial courts, giving both tests to the jury in the same case on strict liability. So in effect, within a strict liability instruction, they give the standard strict liability consumer expectations test and a negligence test at the same time.
With all due respect for this position, we always say that when we adopt instructions, we're not commenting on the law. It seems that your argument would be better raised in a case in controversy, and then the court decides it, whether giving both are confusing. I just have a problem, now that, as I said, that I realize it's been in there, to just saying that we ought to make a decision to remove it. So just because I know you only have limited time.
Let me ask one other question, a follow-up to that. The risk-benefit analysis, is there an issue with regard to whether that applies to both manufacturing defect and design defect?
It does not apply to manufacturing
So if you combine them, still, it should not be in one, no matter what. The only where it was before was in the design defect area.
That is correct.
Okay, so if that understood, that if you separate them, it would only go into that area, remain where it was.
And I just want to make, then, following up, and maybe we ask the committee again, how did they deal with this issue that it's absolutely confusing and could be to a trial judge if they were combined that way? Was that discussion had? Because nobody, I think, would intend, again, on a manufacturing defect to use a risk-benefit analysis. Was someone trying to argue for that?
No, Your Honor.
Okay, so.
But at the committee level, and this is in the committee submission to this court, the committee, the majority of the committee, certainly there was a dissenting viewpoint of some, but the majority of the committee was convinced that it was no longer satisfied that this was a law in Florida. And I think the committee's obligation at any point in time that it finds that there is an instruction that does not express the law in Florida, whether it's been there for 6 months or 2 days or 20 years, it is obligated to come forth and say, this instruction is incorrect.
But the majority didn't, the committee submission kept it in there.
Yeah, what the committee did is they got to the point that they decided that it was no longer satisfied that this was law in Florida, and then they punted. We say that they should have gone the next step to be intellectually honest and take it out of 403.7. It is a negligence standard that is part of a negligence case, not part of a strict liability.
It is part of the restatement towards under strict liability, isn't it?
It is not. Under 402A, there is no mention of risk-benefit whatsoever. It's in the new restatement third, which came out a few years ago, highly controversial. And the new restatement would abolish 402A, would essentially overrule West v. Caterpillar. It would be strict liability in name only because it is totally a negligence standard under the new, and most Supreme Courts around the United States have rejected it. But we shouldn't even be arguing about that because that has to come up, I submit, in a case in controversy on whether you're going to adopt this new restatement, which is a totally different animal and a very radical animal.
All right, why don't we go on to 403.9, which is the negligence?
Certainly.
Where did this come up? And that defects which results in a product being in an unreasonably dangerous condition?
It came up from an argument based upon some district court of appeal cases where there were inconsistent verdicts or where the court decided that there was no proof of negligence. And in those opinions, there is language that says in those cases there had to be proof of an unreasonably dangerous product, because the claims in those cases under negligence and strict liability were exactly on the same facts. And that was used to support the argument that this should be inserted in there. I think the instruction is wrong, because there are cases where you can have a negligence claim under one set of facts, strict liability on another set of facts, and if you approve this instruction, what you are saying is in every single case you can only have a negligence claim if you prove that the product was unreasonably dangerous, which is tantamount to proving strict liability.
So you would just want us to take out the modifier that says
exactly
it would end with circumstance.
Exactly. It'd be the traditional negligence instruction that this court has already approved.
403.11, there was about compliance with government rules.
Yes.
There's not an instruction. Is that correct?
It is not an instruction from the committee. The committee did not submit an instruction on that point. What happened was the Products Liability Subcommittee approved an instruction. That statute, 467 point whatever it is, the statute's called the Government Rules Defense, but what it is, it's a mirror image. It says if there is evidence of violation of a government rule, there's a presumption of liability. If there's evidence of compliance, there's a presumption of no liability.
That's from the statute.
That's from the statute. That's what the statute says. And it's a presumption, not an inference, according to the statute. The subcommittee approved instructions based on the. When it got to the full committee, you'll see in the minutes if you read them, we got wrapped up in a whole big argument about whether you instruct on inferences and bubbles and vanishing things and all the rest of this stuff. And the committee decided not to send up the instruction that had been approved by the subcommittee. For our side, we say there ought to be an instruction. It ought to be what the subcommittee approved.
But shouldn't it have, if it's going to be instruction, shouldn't it go both ways?
Yes. Oh, yes. And it did go both ways. When it came out of the subcommittee, it went both ways. There was the violation side and there was the compliance side.
Did the subcommittee address whether it was a burden-shifting presumption or a vanishing presumption?
We discussed that and everything that you can imagine up one side and down the other. I don't think we came to any conclusion about, well, I take that back. We did come to a conclusion that it was not a vanishing animal because you wouldn't give an instruction on it if it was vanishing. So by the mere fact that we submitted an instruction, we had to conclude that it was not vanishing, and there's nothing in the statute that would indicate that it is vanishing. And
the statute would, on its face, seem to be a declaration of public policy.
Well, that was the subcommittee's view of it, and therefore that we had to instruct on it, that parties were entitled, whichever way it fell, parties were entitled to have an instruction on it, whether it was a violation or whether it was compliance. So that's the position as far as that's concerned.
What has been happening on the ground since the statute has been adopted for how it's being applied? Are there any cases from the lower courts on it?
Not that I'm aware of, and not that we heard of in our consideration of this at the committee level.
It's been a while since I looked back, but are there instructions when there's violation of traffic rules what does that say?
It says conceptually it says the same thing that what the subcommittee came out with, which is what we're suggesting the court should approve.
I guess I'm surprised, and just tell me, that the plaintiff's bar wants an instruction that says compliance with government is a presumption of no liability with compliance with government regulations.
No, we want the instruction that says violation of the rules. Well, that's what's good for the goose is good for the gander. I mean, so that's the way it falls out. I mean, you can't have one in that.
There were instructions that were given that said violations, that there was a presumption of.
There is in the 401 general negligence, which you have already approved. We have the standard instruction on violation of a statute and violation of an ordinance, and those didn't change. They've been in the instructions for years and years and years, and all we did at the subcommittee level was take those instructions as a model and craft the instruction that...
You're being very candid about this. You agree it would go both ways.
Absolutely. I mean, you can't have it one way and not the other. So.
And then I guess crashworthiness was the other sort of big one that we were concerned about. It seemed like there was something missing from the instructions, the way
you all raised it. I don't think anybody on the defense side is going to comment on that today, but we made... the Florida Justice Association made a few suggestions for some minor improvements in that instruction. I don't think that they are or should be very controversial.
I guess we were I mean, I know my concern was shouldn't there be clarification under DeMario that the plaintiff's not claiming the defect caused the original accident?
Well, that's one of the suggestions that we made, to put some language in there to that effect. I can't imagine that the defense would object to that. We also suggested putting a footnote, not a footnote, but a note on use in to the effect to clarify that the fault of the other people are not an issue in those cases. That would go in as a note on use, which is directly out of DeMario.
Oh, I know the other one I had. This 403.18. I don't know. Did we ask you about that?
Defense issues. You did not ask me about those.
The affirmative defense of where the risk-benefit is being added as an affirmative defense.
Correct.
Where would that be used?
Why would that be used?
How would that be used?
How would that be used?
Would that be then a defense to negligence or to strict liability?
Strict liability or negligence.
So wouldn't that puts? So you agree that that would be an appropriate place to put it and take it out of?
Correct.
The burden.
Correct. And if you go back, it can't be both. If you go back and look at 402A, comment K is essentially a risk-benefit defense under 402A. That is for an unavoidably dangerous product where the manufacturer cannot make it completely safe and gives proper warning and directions. This court has written an opinion in the Searle case noting that this is an affirmative defense. And we say that that supports putting it as an affirmative defense and not part of 403.7.
But the committee put it in both places.
The committee put it in both places because the committee was trying to cover the waterfront and put it in both places with notes saying it's one or the other, trial court. You decide. You have to decide, trial court. You can't give it here as a part of the plaintiff's burden and also give it over here as a defense.
Are there cases that has gone both ways, that you put it as a part of the... No?
No,
So
Your Honor.
All the case law says it's an affirmative defense?
They're going to argue that it's not an affirmative defense, that it ought to be in 403.7, but I think we both agree that it doesn't go both places. It either goes one or the other.
Okay.
We say that when you read 402A and when you read the cases, it is an affirmative defense. The burden is on the defendant to raise it and prove it as an affirmative defense.
Do you think, as somebody who's been a lawyer for a long time and in the courtroom, I think this is the recipe for disaster. Is it says pending further development in the law, they take no position on whether the risk-benefit test is a standard for product defect that should be included in 403.7 or an affirmative defense under 403.18. And then you say they shouldn't instruct on both. But how's this trial? I mean,
that's what you've got right now under PL4 and PL5. Under PL5, it says the committee takes no position on whether the proper test is consumer expectations or risk-benefit. You decide, court.
Well, what they do is then you said that they just read both. But We don't have it right now as an affirmative defense, so to further confuse the trial judges.
But you should straighten it out and take it out of 403.7, put it over as an affirmative defense. You've got case law to support that, and you don't have case law to support keeping it in 403.7.
All right, tell me the best case that says that that's where it should be.
The Searle case.
And that's a case from this court.
It's out of this court.
And it says specifically...
It's an affirmative defense. A risk benefit is an affirmative defense. And if you look at 402.A, adopted in West, comment K, it's an affirmative defense, which this court adopted in West. So West and Searle say it's an affirmative defense and not part of strict liability. There's one other thing that I should note as far as the defenses under 403.18, and that is what is currently in the instructions as, I forget which subparagraph it is, but it's called state-of-the-art defense. Joel Eaton makes a very good point in his comments. That is not an affirmative defense. It is an instruction on how the jury is to deal with the evidence. There's no burden of proof involved in it or issue involved in it. And Joel is correct. It ought to be moved up in the instructions and be a standalone instruction at an earlier point in the instructions.
That's subsection G.
Yes, Your Honor.
In deciding the issues in this case, you shall consider the state-of-the-art scientific and technical knowledge and other circumstances that existed at the time of the manufacture.
Correct. It's really
not a affirmative.
It's not a defense. Although if you look at the statute, it's got the title of the statute.
That would be part of the standard product liability.
It ought to be moved up in the instructions. I think where it should go is where 15 is right now, 403.15.
So that wouldn't be something I would think that the defense lawyers would object to. That seems like that's logical.
It seems logical to me. None of the defense interests have commented upon it at all. Joel just brought it up in his comments, and I think he is correct about that.
How about the proposal that would merge the model instructions 7 and 8 into one, just number 7?
It doesn't. We're not. The committee did not suggest merging the two together. Mm-hmm. The committee determined that current model instruction number 7 ought to be abandoned because it's just outdated and not used anymore. It's an express warranty instruction, and there are very, very.
So the committee is really saying you should get rid of 7 and 8, or just just
get
7?
Rid of 7, and then we took number 8, which is a hay baler case, and we just plugged in the new instructions in number 8. We really didn't change anything other than put the new instructions in there. So we're not merging, but we're just getting rid of what really is an obsolete. The trial judges told us they never see these cases anymore, and rather than go to the effort of revamping it and remodifying it to fit the new instructions, we just deleted it.
I have a note, and you may know what this refers to, whether it alters the note about whether the bystander must be foreseeable. Isn't that a change in? That
is not a change. In your current instructions, if you look at PL4, PL5, and probably PL4 too, there is a phrase in there that covers bystanders and is covered in the notes. That was taken verbatim and moved over to the new instructions. No change whatsoever. In the note on use, we expanded the note on use to be a little more descriptive of the bystander issue, and courts had said in the opinions about it. But there is no change as far as bystander. In West, this court decided that the claim was for both the injured party that was directly using the thing and any bystander that was injured as a result of it. So bystanders have always been proper claimants in strict liability, product liability claims. And there's been no change in the substance of the instruction in that regard. It's the exact same language.
Well, we certainly thank you, Mr. Stewart, for your presentation here today. And
thank you very much. I only went 7 seconds over.
Mrs. Lemon?
Yes. Good morning. May it please the Court, Wendy Loomish from Carlton Fields. Thank you very much for the opportunity to appear today. Let me start by saying there is some agreement. We agree on the state-of-the-art instruction, the question that was just asked. We agree that shouldn't be on the defense side. So maybe we're all making some progress. I think this whole...
I actually seem to think that's a helpful thing for the defense.
True.
So I think the concession is showing there's some interest in just trying to get the law the way...
Exactly.
the instructions the way the law is.
Exactly. And I think this whole process demonstrates why in the trial court in the trenches we spend hours upon hours working on charges in product liability cases and having trial judges say, I don't understand, why is this so difficult? I think that the 9 years at least that I labored on the committee with others demonstrates that these really are tough issues. So we really appreciate the opportunity to be able to come before the court and try to clear some of this up. The issues that I'm going to address today relate primarily to Proposal 8, the question of the proper test of defect in a design case, the intermingling of manufacturing and design, the note on use 4 relating to the restatement third of torts, and the reference to the two-issue rule. And then I'll defer to others to address, Mr. Caldwell will address the negligence issue, and Ms. O'Connor will address the issue on the presumption. As former members
Let me just ask you this. Is anyone going to address the risk-benefit and whether or not that is really a affirmative defense?
That's me.
Okay.
I will do that. And certainly as a preliminary matter, as former members of the committee, Mr. Caldwell and I certainly understand our role today is not to argue what the law should be. Our role is to look at cases and try to interpret them, and that's what I hope to do. Let me turn first, hopefully, to one that we can clear up some issues on, the manufacturing defect issue. And Justice Pariente, you asked a couple of questions that I would like to answer on that. First of all, the original manufacturing defect instruction was old PL4, and in that instruction, it said simply, a product is unreasonably dangerous because of a manufacturing defect if it does not conform to its intended design and fails to perform as safely as the intended design would have performed. We agree that, I think everyone agrees, that in a manufacturing defect case, the risk utility test does not apply. And the former instruction said that. We believe that it is important to separate the two instructions for the reasons that have been expressed today. It's simply confusing. They're two different theories. The cases recognize that they're different theories of liability. There are different issues that relate to the two, and putting them together and telling a trial judge, if you have a manufacturing defect case, go into the note on use and pick up a half a sentence and plug it in there. There's absolutely no basis to do that. And so our position is that the court should retain the PL4 instruction as it was. Now, you also asked the question about, is there a change in the new instruction? If we just pull out what the committee has recommended and move it over, is it different? And the answer to that is, yes, it is different, and we think it's different in a significant way. The difference is, as I mentioned, under the prior version, the question was that the jury had to decide whether it conformed to the intended design and then whether it failed to perform as safely as the intended design would have performed. In other words, it wasn't just enough that it didn't conform. Maybe you put the nail a little bit further over. That wasn't enough. You also had to show that it failed to perform as safely as the intended design would have performed. The new instruction, as proposed in the note on use, would instead put an or, and instead it would read, a product is unreasonably dangerous if the product was not built according to its intended design, or because it failed to perform as safely as an ordinary consumer. So under the new proposed instruction...
But I'm looking, wait. Are we talking about 403.7?
Yes, you have to go to the note on use in order to get the language for a manufacturing defect case, which is our problem with, if you're telling people you got to go to a note on use to add language, why not keep them separate? And so my point is, separate them, for one, and two, to answer your question is, was it the same? No. The proposal on the table, when you pull up note on use 1 now, is going to give you a different instruction than what was previously provided.
But let me make sure. I mean, I understood that the commentators were the majority of the commentators agreed these should be separated. So there's agreement on that point.
Well, I think that all of the comments, quote-unquote defense comments, where they should be separated. Joel Eaton, who was a member of the committee at the time, in 2004, we changed the manufacturing defect instruction. He was on the committee at that time and agreed to that language. I believe that the FJA and Mr. Stewart's comments, as well as Judge Farmer's comments, suggested they should be one instruction and that they should be merged together. Now,
I didn't hear that this morning. I heard this morning they should not be combined. Am I?
The FJA, as I understand it, the FJA, Mr. Stewart and Judge Farmer believe they should be combined in one instruction.
Are you still on the committee?
No.
Okay.
Actually, Mr. Stewart, myself, and Dick Caldwell, we're all off the committee now.
I think in the comments that we received, the FJA said that combining them would make them confusing. And I thought that's what he said today.
Maybe
I'm sorry, I didn't mean to
I may have misunderstood, but
okay.
Clearly
You're clearly on the record as saying these should be separated.
2 points on the instruction. They should be separated, and it's wrong.
Okay. If they're separated, should they be different than what is now PL 4 and 5?
In my opinion, PL4 was a correct statement of the law and need not be changed. I will tell you that the position of many on the other side is that it didn't accurately reflect the language about the consumer expectation test. It said fails to perform as safely as the intended design, and there were those that believed that it should instead say as safely as the ordinary consumer. I would submit that if you change it so that there's an and there's a requirement now that the product was not built according to design and failed to perform as safely as the ordinary consumer, I think that's a correct statement of the law. So I would have no problem if the current instruction were modified slightly as long as the and is put in there.
So it says it does not conform with the intended design.
And.
Now it says and fails to perform as safely as the intended design would have performed. You would agree that it should be substituted with the consumer expectation.
I think the PL4 as it stands is fine, but I would have no problem with changing that language of the second part of it if that's what the court believed conforms. But I think that as it stood, it was fine.
But that was the proposal. If the product fails to perform as safely as an ordinary consumer would expect, when used as intended or when used in a manner reasonably foreseeable by the manufacturer. That the majority agree with that. I didn't.
Right. Notably, though, the majority put an or in there, and we're saying it has to be an and. Okay. I know it gets a little complicated, but those are the points on that.
We should probably send out. Here's option A, B, C, D. Raise your hands or get the option finder.
We did that when Bill Wagner was the chair of the subcommittee. He used to give us the check off, and we still couldn't agree. The other quick point I would make on the manufacturing defect issue is there is a note on use 1, that talks about pleading and proof. We think that that's inappropriate in a jury instruction to talk about pleading and proof requirements, and in addition to that, we believe that that's an incorrect statement. We've detailed that in our submission, and so I'll leave it at that for the moment, and let me talk about the design defect risk utility test, because I think that's the other issue of concern to the court. We believe that the new instruction is correct. It includes both tests. It reflects PL5 as it was before. So we have no problem with the instruction. Our problem is with the note on use in 2 respects. The note on use suggests that the risk utility test is not a test of a defect and that it's an affirmative defense. Let me start with the affirmative defense. Mr. Stewart misspoke, I'm sure, when he said that Searle was a Supreme Court case. It was not. It was a second DCA case. It dealt very specifically with comment K, which is unavoidably unsafe products, a very narrow category of products not the norm. So the suggestion that that case supports the notion that in a product liability case, the risk utility test is an affirmative defense, I submit that's incorrect and not supported by Florida law. No case holds that it's an affirmative defense. The rest of the story relating to the risk utility test as a test of defect, our proposal, what I would submit is appropriate, is to retain the current comment 2, which basically says, here's both tests. Pending further development, we can't tell you which one to use and when to use it.
Well, let's go back. I think that there you could be having different instructions in every district, every circuit. It's different. Is there a case that says that there is some form of risk-benefit proof that is required before, as a condition precedent, to a design defect verdict?
I believe that there are multiple cases in Florida that support the use of the risk-benefit test.
I didn't say that.
I'm sorry.
Please answer it as I ask it. Not, I understand there are a lot of cases that talk about a lot of different things. Is there a case that says that there is a proof element with regard to the risk-benefit concept as part of your burden of proof in prevailing on a design defect case?
I think framed in those exact words, no. But
okay, that's the problem we get into, because then you're saying it's not an affirmative defense. They're saying it's not part of an element of a claim. So, it seems to me that it's probably neither one. If there's not a case that holds that it's one or the other, then it's something else. It's not part of those. It ought not be instructed on as part of a claim or defensive burden.
Well, what I would say on that is there's two cases from the Florida Supreme Court, the Auburn case, which there's been no discussion of, and radiation technology. In both cases, the issue was not directly what's the test of design defect in Florida, which is why I answered the question no when you asked that. However, both cases look at the question of what does unreasonably dangerous mean, and as an element of strict liability, 402A. Because remember, 402A says that a product is defective if it's unreasonably dangerous. It doesn't then define what unreasonably dangerous is. So you look to cases. In the Auburn case, they were deciding whether or not to adopt the patent danger exception as a defense, and the court in that said, really the question is whether or not the product is unreasonably dangerous. We're going to use the balancing test, the risk utility test, and that's how you explain why a knife is not defective even though it can cut, because does it have an unreasonable danger? Following that, this court in radiation technology was asked to look at whether or not a product was inherently dangerous if it did not cause injury to a person. What the court held in that case was inherently dangerous is really a quote-unquote passé concept in the context of now strict liability under 402A, and they said the balancing test defines unreasonably dangerous, and in that case they followed the Auburn case. Since that time, multiple district courts have looked at this issue in some context and have seemed to recognize the risk utility test. Light versus Welldark is one of them. It was a summary judgment. The court looked to both tests of defect and said there's a fact issue on consumer expectation and risk utility.
But what's happening basically, you said you spent a lot of time with the jury instructions. Are judges instructing and using both the consumer expectation and the risk benefit? Are they using both those?
In many cases, they're using both. As the courts, I'm sure, aware, in the Force case, the court decided to only use the risk utility test, and it was reversed. And in that case, the court held that both tests should have been instructed on. Again, a case suggesting the risk utility test is one test. And to be clear, I am not suggesting the law is clear in this area. If it were, we wouldn't be debating it for 9 years or more. The point that we make is the current comment says that there are two tests, and here are some cases that address it. This whole debate started at the committee after the Force case, because I recommended at that point that we need to add that as another case addressing the issue. And I think that the best service that we can do to the bench and bar now is to just put a string cite to all of the cases and let the litigants fight it out in the context of a particular case. There is no black letter law in terms of this test applies in this case, this test applies in that case. Maybe there will be when the appropriate case comes before the court. But until that time, for the comments to suggest that it's one or the other when the law does not support it, we think will cause confusion that's absolutely unnecessary in a circumstance where litigants have been going through.
When you say one or the other, either part of the claim or an affirmative defense?
Well, I think it's clear the only circumstance that it might even be considered an affirmative defense under Adams is a comment K case, which is a specific case involving an unavoidably unsafe product. In the normal circumstance...
In a design?
In a design case.
Okay, so at least we're to agreement there. It doesn't apply in the manufacturing context.
Correct.
It is design. Okay, so we're making some progress.
Yes,
so we can
I'm sorry,
okay.
and we do agree on that.
Okay.
It only is design, but if there is an exception at all and the risk utility test as a defense, and I don't concede that it's ever a defense, it would be in the context of comment K, and the affirmative defense would need to say that. But that doesn't change the issue of whether the risk utility test is one of the tests that has been cited in cases in Florida. And we believe that the current comment, which says that pending further development, here are some cases, we believe that's appropriate. Right now it says these concepts are discussed in, and right now it lists radiation, Cassisi, and Adams. We think that the only thing that should be done is to add these other named cases to it and address it. And I know I'm over. If I can just make one more quick point. There's a note on use 4 relating to the restatement third. Our only point on that is, since the time that the committee addressed the issue, another case has come out of the 3rd District that actually does recognize the restatement third. We think the comment needs to be reflective of that newer decision. I'm not suggesting the risk utility test has been adopted in all the courts, but it needs to correctly reflect the cases. The comments opposing it said it's an outlier. It is not for this committee to decide which case is an outlier and which is not.
Thank you. With that, thank you very much for your presentation. Mr. Caldwell?
May it please the Court. My name is Dick Caldwell, Romberger, Kirk, and Caldwell in Tampa. With the Court's permission, I'll address the negligence issues, which are comprehended within Proposals 10 and 11. The primary problem that's presented by the proposed instruction 403.9, the negligence instruction, is that it fails to mention that the jury must find that the product in question is defective. And the same flaw is present in the instruction 403.10, the failure to warn, and in the note on use 1. Now, as support for my proposition, I really can't do any better than to quote the words of this Court from West versus Caterpillar, which said, at the heart of each theory, that is negligence or strict liability, is the requirement that the plaintiff's injury must have been caused by some defect in the product. And interestingly, defect is capitalized in the opinion. Generally, when the injury is in no way attributable to a defect, there is no basis for imposing product liability upon the manufacturer. And they cite the Royal versus Black & Decker manufacturing case, which we've also cited in our comment. By studiously avoiding the word defect in the proposed instructions, 403.9 and 403.10 misstate Florida law by attempting to divorce the negligence concepts under discussion here from the very essence, the very basis of product liability law, which is that there must be a defect. Then this same problem incidentally spills over into 403.15, the issues.
Well, if we view it from that perspective, I mean, you're basically arguing that all negligence and strict liability concepts should be presented together then.
No, sir. No, sir. They are different.
Well, I was under the impression, correct me, I was under the impression that West was a strict liability case. West was did not decide negligence issues.
West was the very issue before this Court in West was whether to adopt strict liability.
Strict liability, right.
And, of course, they decided to do that. But in so doing, the Court used the language that I just quoted, that is part of the rationale for the adoption of strict liability.
And what has the instruction said in negligence with regard to products up between West and until these proposals?
There was no negligence instruction in products.
There was nothing.
There was nothing. What we did.
And what was the practical approach?
The practical matter is we basically adapted 3.5, and we would say negligence is the failure to use reasonable care, whether et cetera. The issue would be whether the manufacturer was negligent in manufacturing, producing, selling, whatever it is, a truck, product, crane, whatever it was, with a defect in the steering system, braking system, whatever, which caused injury.
Okay.
So that's the way that it was handled typically.
So, I mean, this is where I see your point, but I think of the case, say if the plaintiff decides they want to bring the failure to warn as a negligence claim, because as opposed to the strict liability on failure to warn. It seems to me that somebody could be negligent in how they warn and it be a legal cause of injury. Obviously, they have to prove that without having to say, and that failure to warn left the product in an unreasonably dangerous condition. That seems that it's adding this element that is required for the strict liability, that it be unreasonably dangerous, and bringing it over to the negligent side.
No, Your Honor.
Why would that be? And why is that necessary? In other words, a jury understands it's a failure to warn or failure to negligently warning.
If I followed the court's question, that was sort of the problem that was presented in the Moorman versus American Safety Engineering case, in which the jury there found no defect but negligence. And the defendant there argued, well, that's an inconsistent verdict. And the Fourth District Court of Appeal pointed out no, that there was evidence of both defect and warning, so that the jury could very well have found, A, no defect in the product that at least was present when it left the hands of the manufacturer, but that there was a negligent failure to warn of a defect which occurred later. So, the court's correct. Number one, there is a difference between strict liability and negligence. However, if you're talking about design or manufacturing defect, the negligence in those issues has to revolve around the defect.
Well, but is there a note on use that says that? In other words, I think that the instruction is fine, but it seems that by putting in that results in a product being in an unreasonably dangerous condition, is merging these two theories to a way that I think could be confusing to a jury.
Okay. We do not have a problem with in fact, we objected. Ms. Loomish and I objected to the inclusion of the words unreasonably dangerous in that proposed instruction. On the basis, one, it's a poor substitute for the word defect. Okay, because you're correct. Unreasonably dangerous is a strict liability concept. Defect, per West versus Caterpillar, per Cassisi versus Maytag out of the First District Court of Appeal, per Liggett versus Davis, Fourth District Court of Appeal, 2007 case. The word defect, the concept of defect, is inherently embedded in a negligence product liability claim. You can't get around it. The product has got to be defective.
But her question is going to the warning aspect. So are you saying then that the lack of the warning produces the defective product? That's the argument.
That can happen.
So that word has to come in.
Yeah.
In all situations?
I think we're in agreement with, for actually the Florida Justice Association, that the words unreasonably dangerous need to come out.
Is that always the?
Should be in.
You could just. We had proposed some language to put in place of that, which said that the jury must find that the product is defective. Is it a true statement to say that any time you deal with a failure to warn, negligence in that arena, that it must be a defective product? The product may be fine. It's just that you haven't warned properly as to whatever. That's 403.10, negligent failure to warn. And so that's covered sufficiently there? That's a separate instruction if it's a negligent design defect.
Well, you have, though, in that one it says which makes the product unreasonably dangerous, so it also has the same language.
Again, if you use the word defect, then you avoid that spillover.
Well, again, I asked that same question, though, to a warning. Does, under our law, and I don't know the answer to this, but I mean, it seems to me that you could have a failure to warn, but that doesn't make the product defective. It's just that you have not warned of whatever it is. The product may be operating absolutely the way it was designed and intended. But because of that, there needs to be some kind of warning to it. It would seem to those safety devices, the cuts and
I think that is what.
But it's not a defective product. It's a failure to warn of this.
That's what 403.10 was designed.
Well, I understand, but then so you wouldn't even have defect there, though.
Correct. You got to have defect there.
Why?
Because the defect's in the warning.
No. I mean, I respectfully, in thinking of it, I know that a lot of times plaintiffs do want to get warning as a defect, and they have that right to try to show that as strict liability. But when you're just doing plain old negligence, to try to have to describe it as a defect, which brings you right back to the strict liability instruction, seems that it ends up having risk of the jury merging the two concepts. And it's been working. I mean, it seems like it's working pretty well when you haven't had an instruction on negligence and just use the standard one.
Right. The concept of defect pre-exists strict liability. The concept for defect, the Royal versus Black & Decker case, was decided by the 3rd District Court of Appeal in 1967, 9 years before the adoption of strict liability by this court. So the concept of defect is as I said, it's the cornerstone of products liability in Florida. I mean, the cases are unanimous that you have to have the concept of defect in a products liability case. And an instruction, a negligence instruction, which totally omits the word defect, does not conform to the law of Florida. Again,
and with that, Mr. Caldwell, you have used
thank you,
all of your time. Ms. O'Connor?
May it please the Court, I'm Kathleen O'Connor, and I'm here today to address the government rules jury instructions. I'm here because the government rules instructions have been pulled by the committee, and everybody who has submitted comments on this, whether for the plaintiff side or the defense side, agrees that there should be an instruction on this. And I think, Justice Perianti, I'd like to make a couple of comments about some questions that you asked Mr. Stewart. What's happening on the ground, and are there any cases? What's happening on the ground is I do a lot of trial support work as well as appeals, and I would say it's our experience that most judges are not giving an instruction on the government rules, and because there isn't a standard instruction, and the more time that goes by without one, the more the judges think, well, if I'm supposed to give an instruction on this, there'd be an instruction in the book. This statute has been on the books for 11 years. We were successful, I would say, maybe in 2 out of 5 cases. Judges have given this instruction, and we do have a case site where the 11th Circuit approved the giving of a government rules instruction in a case, and we cited that in our papers. It's the Keene-McPeters case. So everyone on both sides agrees there should be an instruction.
That is everyone but the
committee.
Majority of the committee that submitted
yes.
the report.
And that's the only reason I'm here. If everybody agreed, I would have stayed home, but the committee does not agree. So we think,
I think wasn't the problem that was expressed is whether this is a rebuttable presumption or a vanishing presumption? I guess is that what caused the hang-up, if you know?
I think that was one thing that caused a hang-up from my reading through the committee notes. But I think that in this case, it is a if we have to put a label on it, it is a burden-shifting presumption when you're talking about the manufacturer failing to comply with the standards. If that's the situation, then the manufacturer, the presumption applies and the manufacturer has to overcome that presumption.
Why wouldn't it go the other way too?
Yeah.
Well, because the burden is already on the plaintiff to prove defect. So if the manufacturer complies, the presumption applies and the product is presumed not to be defective, but the plaintiff can overcome that because it's a rebuttable presumption. So there's no shift there. It's where it always was. But from the other side, if the manufacturer doesn't comply, then the burden shifts to the manufacturer to show a lack of defect or negligence.
I guess the issue on this one is that statute seems, at least on saying that if it complies, it's presumed to be non-defective, is a substantive change in the law. I mean, correct? I mean, I remember always making the argument, it doesn't matter. I mean, the government rules are the floor. That has nothing to do with whether the product is defective. So it just seems that I wish this case would come up as a case so that we could decide the issues as opposed to trying to figure it out in the jury instructions. But it hasn't, right? We have not seen this issue in 11 years.
No, it's only come up in federal court in an appeal. But
maybe nobody's litigating in state court anymore on products liability?
Yes, but
maybe we'll get a certified question from the 11th Circuit one day.
But we believe that we aren't asking for a change in the law, a change in the substantive law, because the legislature has said what the law is.
I should say the statute itself is a change in the substantive law. What you're saying, that it should be given effect through a jury instruction.
Correct, because otherwise it's just sitting there and has no meaning, really. Unless there is a jury instruction on it.
And some judges are giving it and some aren't.
Correct. And I would say more aren't. And when they aren't, they're saying, well, it's not a standard jury instruction. So it kind of goes in a circle. And without the jury instruction, I think it's going to continue to go that way since the statute's been on the book for such a long time. And also, I do think in our submission we point out that the legislature was thinking about jury instructions in enacting this very statute. And I think it's been pointed out that there is negligence per se, and the committee notes show that the legislature said, well, it's a one-way street. If someone violates a statute, there's an instruction on that. What if they comply with statute standards rules? Shouldn't there be an instruction on that? And that is how this whole thing got started. So obviously the very idea of passing this in the minds of the legislators was so that there could be a jury instruction. And we think that giving the instruction is consistent with legislative intent.
And thank you very much for your comments here today also. I believe you have a minute or so, Ms. Gunn, for rebuttal.
I would love you to address that last issue, which is why did the committee decide that to punt and not adopt an instruction on something that's a statute that's been passed by the legislature?
Your Honor, the committee struggled with whether it was the type of presumption about which you would instruct the jury, and finding no evidence in the statute that it was a burden-shifting presumption. The majority of the committee voted not to have the instruction. What we did do is provide a new note on use saying, although we're not proposing an instruction, we note that this issue's out here, and we leave it to the parties to make the argument for an instruction in a given case, hoping that would prompt some sort of actual case and controversy to come up for the court. I do want to briefly discuss the merger of PL 4 and 5 because there were people who commented who were in favor of that merger, and that's a separate issue from the risk-benefit issue. Judge Farmer, who was chair of the Products Liability Subcommittee and has filed his own comments, was the major proponent of merging those two, and the reason was his theory that there was no burden on the plaintiff to prove whether it was a manufacturing defect or a design defect, and that was really just a construct that lawyers use, that we're comfortable with as lawyers, thinking of it one way or the other.
But you see now that even if some of the tests just don't apply equally.
And we definitely had concerns in the committee about that confusion issue. I mean, Judge Farmer noted this in his comments. When something is the product of this much debate, it's a compromise, and that's not always the way that one person would sit down and write it. I want to note that the FJA comments at page 5 and 6 do support the merger of PL 4 and 5, and Mr. Stewart's comments at page 4 also support the merger of PL 4 and 5. So I think there was some confusion about whether any of the commentators did support that.
But not as it stands now.
But not as it stands now. Then that leads us into the issue of should risk-benefit be in there at all. But those really are two separate issues, and the court could separate or merge PL 4 and 5 and then separately address the risk-benefit question about whether it should be in there. The pending further developments in the law construct is something that the committee has used in the past when we've identified issues where we thought the law was not settled, and recognizing that our job is not to make law in the committee, hoping to at least give trial judges a comfort level. Although they don't see anything in the book, sometimes they won't give the instruction. If we put the note on use in there saying, we're not sure, it gives trial judges the comfort level to make the ruling and let the case go up on appeal and let the law develop. So that's the purpose of using that. If there's any other questions I can answer, I'd be happy to do so, but my time is up.
All right, thank you.
Thank you.
And the court would just like to echo the comments of Justice Lewis that we all appreciate all of the work that has gone on over the years in these instructions, and our questions about it is not a reflection that we don't appreciate it, because we certainly do, and we know that it is hard work in these committees to come up with these instructions for the court. So we really appreciate the hard work of all of you, and thank you.
Should we give you back the notebooks for recycling?
Thank you. The next case on the court's agenda this morning is Desiree versus State of Florida. Are the parties ready? You may proceed.
Good morning. I'm Eric Pankert on behalf of Mr. Dessart. We're here on an appeal of a denial by the lower court of his 3851 post-conviction motion. Okay, this is a defendant. He waived mitigation, correct? There was a waiver of mitigation.
And your points are all about whether he was competent to waive it, and then the second point is whether he should have still presented additional evidence at the Spencer hearing, correct?
Those are precisely the two issues I was getting ready to address. Basically what happened in the case was ultimately Mr. Desor's counsel prepared a form for him to sign, and it was actually presented to the court, and within that form it states, I join in the state in seeking a death sentence. And this was the first time in the case of Mr. Desor, although...
Was this presented, was that note presented to anyone? I mean, was the note given to the court, to the state, who had this note?
The defense attorney, Mr. Watts, had it's a note, it's a form that was filled out by the lawyer and signed by Mr. Desor and presented to the court as a waiver. Actually, there was two different waivers presented. There was one written waiver that Mr. Watts had prepared before the penalty phase, or before the trial took place, and then there was another one that he prepared after Mr. DeSore said he didn't want to present any evidence.
Is that in essence what defendant doing when they waive the presentation of mitigation evidence in these death penalty cases?
Well, I think there's waiving presentation of mitigating evidence is one thing, and then signing a form saying I join in the state in seeking a death sentence is an entirely different matter. And in this case, there was mental health experts hired at the time, or a mental health expert hired at the time, Dr. Mayer, who had seen Mr. DeSore initially back and around. He had performed 2 evaluations of Mr. DeSore, and he found him at that time in March of 2001 to be competent, and he also found statutory mental health mitigator of a post-traumatic stress disorder. So
that's my problem, though. What you're saying is you're saying that that somebody who is signing a paper that says they're joining in the seeking the death penalty when they're waiving mitigation, that must give rise to the person not being competent. And you haven't attacked whether the waiver was knowing and voluntary in terms of what was said in the proffer. So I'm not sure how it follows that someone should be on notice that he's become incompetent by filing that paper. Is that your argument?
Well, it's my argument, and it's also what the mental health experts who testified at the post-conviction hearing also testified to. Dr.
But how do
Mayer,
they add in? Did they add in the fact that at a later point, didn't he say, Judge, I don't want the death penalty, I want you to give me a life sentence? Don't you add that into the equation also? And did they?
Well, to my way of thinking, the court that denied the motion didn't weigh that part of it, or didn't consider that part of it, because it is true that Mr. DeSore later, at the Spencer hearing, said that he had changed his mind and that he wanted mitigation evidence presented. And at that time, at the Spencer hearing, the lawyer didn't present the mental health mitigation testimony that was available through Dr. Mayer, because through the testimony of Dr. Mayer, he hadn't been called by the defense counsel to consult with him about the fact that Mr. DeSore had signed this form that said, I join in the state in seeking a death sentence. This isn't my opinion about what the significance of that. We had 2 experienced mental health experts in the case, Dr. D and Dr. Mayer, both said that's a very significant difference between a general not wanting to put forth mental mitigation and saying, I join in the state in seeking a death sentence. And Dr. Mayer was crystal clear in his testimony that he said, had he been contacted, and he hadn't seen Mr. DeSore in 6 months, had expired since the last evaluation of him.
Well, but how does that differ from a defendant who says, I didn't do this, I'm not going to put on mitigation, I would rather die than spend the rest of my life in prison? So how does this differ from those kinds of situations?
Well, one thing that's different about this is that Mr. DeSore, I think you have to take these on a case-by-case basis, and we're talking about not a direct appeal issue where you would be talking about whether there was an adequate colloquy from the trial court, because there was a colloquy from the trial court in this case, and they did ask Mr. DeSore about it, and it was a finding of freeline voluntariness. But what we're talking about is post-conviction and effectiveness of counsel, and in this case, the mental health experts themselves, the only ones that testified at the post-conviction hearing, say those are 2 different things, especially in this case where you have a 20-year-old person on trial, and he's said on 7 different occasions the man had tried to commit suicide, and in fairly close proximity to when this crime occurred. There's 7 different instances. So you have to take that into account, and that's what the mental health experts in this case said. Dr. Mayer said, had I been told about this, I would have gone immediately, and I would have insisted upon an evaluation, because this is an additional step. Even Mr. Watts himself stated that as his testimony, that this was an additional step that Mr. DeSore had not done in the past. And we have the testimony of Dr. D stating that he would have also said that there should be another competency exam based on the fact that this man, 20-year-old man, had attempted to commit suicide on 7 different occasions, and here he is, And what he actually told Mr. Watts when he said the reason that he didn't want to go forward with it wasn't what you said, Justice Quince. What it was is he didn't want to be rejected by the jury, and that was the reasoning that Mr. Watts said, that Mr. DeSore said, the reason that he didn't want any mental mitigation testimony presented. But we've got
because he didn't want to be rejected by the jury.
That's what Mr. Watts said. That Mr. DeSore's explanation is that I don't want to be rejected by the jury. So you've got a person there's been an ebb and flow during the case as to whether or not he wants any mitigation testimony presented. At times he doesn't. At times he does. And then the person, prepared by his own attorney, presents a form saying, not that I just don't want to waive mitigation, but I want to join the state in seeking the death sentence.
Isn't one of the factors to look at also is the confidence of counsel that their client is competent? I mean, they are the ones that spend the time with him, and none of the lawyers in this case ever raised the question of competence on the part of the client.
Well, I think that Dr. Mayer had done a competency evaluation, but I think you're back to the lawyers in the case. Although Mr. Barry Cobb, who's experienced defense attorney with over 22 years of experience in many capital cases, said when he saw the form at the evidentiary hearing that he would have immediately gotten another competency evaluation because the person is in effect committing suicide, especially when somebody left.
But people who are competent do that. I mean, is your position that just because he signed the form, that automatically brings in the competency into question?
Well, it's not really my position. That's what the mental health experts in the case said. That's what Dr. Mayer said. That's what Dr. D said, that a person such as Mr. DeSore, and this is not refuted in the testimony because there was no state doctor called in it, that a person of the age of Mr. DeSore, of the prior suicidal attempts of Mr. DeSore, of the inconsistency of his statements, again, we've got a situation where at one point he wants to join the state in seeking a death sentence, and then later at the Spencer hearing, he wants the evidence presented. So you've got
Can I ask a question? If the form had said, I don't want to provide mitigation, I understand that the legal consequences of not presenting mitigation is that the death penalty. The evidence would indicate the death penalty should be imposed. Does that indicate incompetence?
That would indicate incompetence in the case of Mr. DeSore, according to the mental health experts that testified at the post-conviction hearing. And there were no other mental health experts who testified.
You see, the thing that I'm struggling with here, with what your argument is, and that is that it's almost like this is a shocking phrase. I've told this guy he needs to put it on. Isn't that the evidence that the trial lawyer, kept telling him, here's what you need to do, you can do it, those kinds of things? Isn't there evidence as to that?
There's evidence as to that.
And so that for my final statement, I don't know how else to bring this home to this client other than tell him that the failure to present this kind of evidence is tantamount to imposing your own death sentence.
My position is, in addition to that conversation taking place between the lawyer and the client, there needs to be a mental health expert
under that circumstance as well. So then really every time that there is a decision by a defendant who has been found guilty to not present mitigation, then we must have a per se rule that we need a competency examination, because that is essentially, is it not the legal result when folks don't want to put on any mitigation? They've gone through this trial. The state's going to put on aggravating factors. Isn't that what you're doing? I mean, it's almost like we're playing with words here, it seems to me, and help me understand why that's not the case.
Well, again, I'll go back to the point that it's Dr. Mayer and Dr. D that say that's not the case because of the language. It's a difference. I think there's a significant difference.
Well, they're not legal experts.
Well, they're expert as to whether a person's competent or not competent, and that's what we're talking about.
Well, then that's the case. Then you would say then as a per se rule that when mitigation is refused and the result is going to be the state puts on aggravating factors and a death penalty or the death sentence is going to be the result. Let's face it, I mean, that's just a normal, that's what's going to happen. And to tell somebody that, then it automatically will require competency evaluation.
I'm not arguing for a per se rule because each case...
Well, that's what it sounds like you are, because of this one sentence, and although, as Justice Labarga has said, lawyers didn't see any problems, there's a one sentence in this one piece of paper, and that's going to require, if not, we got to set the trial aside.
Well, it's isolating it in that manner is not the way the mental health experts did it. What they did was said, this is Mr. DeSour. In this case, based on what I know about Mr. DeSour, and Dr. Mayer had dealt with Mr. DeSour, and the fact that he had these suicidal tendencies in the past, and he had these mental health issues already that were known to defense counsel and had been articulated to defense counsel, when you've got that information as the man's lawyer, and he gives you the...
Well, he should have done that anyway. Then when he started refusing to present mitigation, then at that point it's the same thing. I mean, that's just the legal consequences of what's happening. So when that happens, then what you're saying is that a competency examination is required.
I'm saying that the additional language within the form he signed is an additional demonstration that this person has a mental health issue that should be addressed, and that issue ought to be addressed not by just a lawyer talking to him, but by the mental health expert who was readily available, willing and able to go down and do another competency evaluation.
Did the mental health experts say at this hearing that that your client is in fact incompetent now, or we're just referring back to the point where he waived his mitigation evidence?
Dr. D testified that he felt at the time he waived it, he was incompetent. Dr. Mayer, I don't think, took his opinion that far. He just said that he would have strongly suggested, had he gotten the information from the defense counsel, and it's uncontroverted that, there's some question in the testimony as to whether Mr. Watts called Dr. Mayer or not when this waiver process was going on, but it's uncontroverted that he did not give Dr. Mayer the information that he had signed this form, I join in the state in seeking a death sentence.
Did Dr. Mayer still consider his diagnosis valid based upon the trial record, even though the form had been signed?
I believe he still held the same opinion about the post-traumatic stress syndrome being present in Mr. DeSour, correct? If that's what you're asking me.
He still found him to be competent?
Well, he was not. He found him to be competent 6 months before, in March of 2001, and then the process went on. There was no more contact between Dr. Mayer and Mr. DeSour. This form gets signed later in September of 2001, and he was called but not told about the content of the form. But there was not another competency evaluation based on the fact that Mr. DeSour had signed this form prepared by his lawyer.
I think what I'm struggling with is that, first of all, the deficiency prong, we have findings by the trial court in the trial court's order finding essentially that there was no deficiency. Even if something should have alerted him to talk to Dr. Mayer again, because the form was not what, it was an unusual form, which I'm not sure it is or isn't, the issue still has to be whether our confidence in the outcomes undermined. That is, whether if he had sought a competency exam, there would have been a different result, and wouldn't have been able to waive the mitigation, and he would have had I'm not sure what would have happened at that point. So I don't know on this record that you've established the second prong of Strickland, which is the prejudice.
Well, the prejudice would be that a person whose competency was in question was allowed to proceed. That's deficient in of itself, I believe. And also, he didn't present this at the Spencer hearing, for which there was no explanation given by defense counsel at the evidentiary hearing as to why, when Mr. DeSour changed his mind and wanted it presented, that this evidence, and it was mental health.
What did Mr. DeSour actually say at the Spencer hearing? Did he say, I want the counsel to present this evidence, or did he say he wanted the court to consider him having a life sentence. I'm not sure exactly what Mr. DeSore actually said to the court.
He wasn't as precise as you put it, saying that I want the mental health testimony presented, if that's what you're asking. He just said, I've changed my mind. I would like to have a life sentence because I've talked to my family and I don't want to put them through me being executed, I think is what he said. That's a summary of it. I don't know about the precision of what I just said.
Well, at this point, you're well into your rebuttal.
Yes,
Did you want to argue anything else before rebuttal?
I'll sit down at this time.
May it please the court. Assistant Attorney General Stephen Ake on behalf of the state of Florida.
Just on the form that's used, was that a form that the defendant, I didn't look at it in the record, who prepared the form?
The testimony from Mr. Watts at the evidentiary hearing was that Mr. DeSore gave him that information to fill out the form, that he actually typed it up on his computer, but that it was Mr. DeSore's language and that Mr. DeSore was the one that signed it. And Mr. Watts said that he signed the certificate of service, and that was all he signed, and that he was not adopting his position, but he was supporting his client, and that's why he did it.
So he, at that point, when he agreed to follow his client's wishes,
right,
he was making another determination that he was, again, understanding what he was doing,
right,
and that he agreed with it without questioning his competency.
Right, and Mr. Watts never questioned Mr. DeSore's competency throughout his representation. Now, granted, he had only been representing him for a much shorter period of time because this crime happened in '99, and the PD's office came on and had him for 2 years, and then they turned it over based on a conflict to Mr. Watts. But neither the public defender that represented him for 2 years or Mr. Watts at the evidentiary hearing, they both testified. They had no questions about Mr. DeSore's competency.
Before we leave the form, where in the world did Mr. DeSore get the language that defense counsel says he simply put into this form? Is that some language or a form that has been used in other cases, and he may have gotten it from some other inmate or something? I don't think I've ever seen or heard of that.
I'm not sure where the language came from, but Mr. Watts didn't recall doing it and certainly said that wasn't his language. I know there was a discussion about Muhammad at the time that this was taking place, and I think the very first waiver, I think a lot of that language came from the Muhammad opinion, because what happened is the guilt phase, the jury returned their verdict very late at night. It was like 11 o'clock at night, and the attorneys at that time said, we know, well, at least we think Mr. DeSore is going to waive the jury for mitigation because this is something that's been ongoing, but we want to talk to him some more and have the night. So the next morning they come into court, and at that time they file the first waiver, and they then recess the case for the weekend because they want to depose, the state hasn't deposed Dr. Mayer yet. And I want to kind of correct some of the facts that counsel was talking about, is that he says that it's uncontroverted that Dr. Mayer never knew about any of this, but the record at the time, Mr. Watts put on the record at the time they come back on September 11th, they come back after deposing Dr. Mayer on September 10th, and they then issue that second waiver, and Dick Watts then says, I've talked to Dr. Mayer, and he says he's competent to do this. Now, at the evidentiary hearing, they couldn't recall specifics because it's been 6 years.
So are you arguing that this form was actually shown to Dr. Mayer?
No, I do not know whether it was shown to him or not. I'm just pointing out that it's coincidental that Dick Watts says, I know I told Dr. Mayer this. And
he told him the substance of the form.
Right, and he said, and then we also know that he talked to him the day before, and obviously neither one of them could.
When you say he, the counsel talked to
Dr. Mayer
the day before.
Right, the waiver was introduced, and
he on the record.
Right, and he put on the record that Dr. Mayer found him competent to do this, meaning this waiver. That's in the direct appeal record.
But what Dr. Mayer, I guess, is saying is, well, if I had known the exact wording,
right,
I would have questioned his competency.
Right.
But as Justice Lewis was saying earlier, frankly, when defendants are waiving these mitigation, they're essentially saying, "State
right.
put me to death." I mean, there's not. I mean, there may be different parts of it, but that's always been our concern. Why we want mitigation in the record, because that's the effect of it. So.
Well, Dr. Mayer certainly knew that this was an ongoing issue with DeSauer, because he was uncooperative with him. When he met with him for this first visit, I think it was an hour and a half. The second visit was 45 minutes. Mr. DeSauer was not cooperating with him. And Dr. Mayer knew at that time, even when the PD's office was on the case, that it was a strong likelihood that he would end up waiving presentation of mitigating evidence.
But at the actual Spencer hearing, when Mr. DeSauer decided that he no longer wanted to have a death sentence but wanted the court to consider imposition of a life sentence, what hindered, or was there anything that hindered the defense attorney at that point from introducing Dr. Mayer's testimony? Because when you look at the mitigating evidence that the trial court actually find, there's nothing about mental health issues in that, correct?
Well, Your Honor, there's a couple waivers of Dr. Mayer's testimony. At the non-jury penalty phase, the court does a lengthy colloquy after every witness is proffered. Mr. Watts was proffering each of the mitigation witnesses, and DeSauer specifically waived Dr. Mayer's testimony. Then at the Spencer hearing, he changed his mind, and Mr. Watts' attorney testified the only reason he changed his mind is because his girlfriend was there, and she had threatened to cut off all communications with him if he didn't at least seek a life sentence. So his position at the Spencer hearing was, I will allow her to testify, my grandmother, and then DeSauer himself spoke at the Spencer hearing. But he specifically said, I'm not presenting any of these other witnesses that my defensive counsel has investigated and prepared for and proffered. And then even subsequent to that, the trial judge indicated at the end of the Spencer hearing, I realize Dr. Mayer that they have proffered Dr. Mayer's testimony, but I'm not going to consider that because they haven't presented live testimony to that effect. And then gave the defendant another chance.
Is that correct? I mean,
that's on the record.
Well, no. Is that a correct determination that he cannot consider that because it was not presented as live testimony?
Right. If it's just proffered, he doesn't have to consider it.
But I thought under Hamblin and some of these other cases, we encourage trial judges to consider mitigation anywhere.
When it's a waiver, but he has since taken away that waiver now. It's no longer a waiver. He is now presenting a case, and he is presenting live testimony, but he is choosing not to present the testimony of Dr. Mayer.
Did the trial judge not consider in the sentencing order in the original case Dr. Mayer's testimony?
He did not allude to Dr. Mayer's testimony.
And that could have been raised. Was that raised as a direct appeal issue?
No, I do not believe so. I don't recall if that was or not.
Even, I guess, and then the even if, do we know that Dr. Mayer's testimony, it really was about his PTSD and his history of suicide attempts?
And actually, the suicide attempts was really not that much of his testimony. His testimony was post-traumatic stress disorder. Dr. Mayer...
What was the post-traumatic stress from?
Being raised by his mother, who was a dealer of crack cocaine, and living in the home when she was dealing drugs, basically his childhood, and the fact that his older brother was killed when Mr. DeSauer was 16 years old. His brother, who was somewhat of a father figure, was killed. Those are what he based his diagnosis of post-traumatic stress disorder on. Now, the interesting thing with that is, I was going back to DeSauer waiving that, and he was given another chance even after the Spencer hearing and entered yet another waiver saying, I realize that if I don't call Dr. Mayer, this court may not consider that evidence, and again waived that. So
when was that done?
That was done right before sentencing in October, I think it was 26, 1991. That was another document.
And that was on the record or something written?
That's in the direct appeal record. Excuse me?
Was it on the record or something that was written?
No, it was filed by Mr. Watts, by the defense attorney. It was filed on behalf of Mr. DeSauer.
In the form of, I mean, it's something that's written, not just something that was orally done.
No, it's written, and it's in the record, in the direct appeal record. And again, I'm pretty sure the date is October 26, 91, because that's the date that the court actually orally pronounces the sentencing. And I think in that document, Mr. Watts says, we're under the impression that the judge will allow us to present more evidence, but we're specifically not doing that. And that's based on our client's wishes. And that's what Mr. Watts testified to, is that his client was directing him as to which witnesses he could present once he changed his mind. There's been no evidence going back to the actual claim, there's been no evidence to say that he was incompetent at the time. Dr. D testified at the post-conviction evidentiary hearing that in his opinion, any defendant who does this is incompetent. And then Dr. Mayer's testimony was, well, if I would have known...
Well, let me just stop you right there, because as I understand the defense argument, was the doctor saying anyone who signs this kind of statement is incompetent, or anyone who waives mitigation in a death penalty case?
Dr. D's opinion was anybody that waived mitigation is incompetent. And he basically says that's an abandonment and that he's not assisting his attorney anymore, and that therefore he's incompetent. I think he did say that he had one case where he examined somebody that waived it where he found him competent, but as a general rule, his belief was that anybody that did that was incompetent. Dr. Mayer said that if he was aware of this specific second waiver, that it would have raised a question in his mind as to competency. But again, the record reflects that the trial attorney, in fact, placed on the record that he had spoken to Dr. Mayer about this and that he had found him competent. Now, Dr. Mayer, 6 years later, says he doesn't recall that conversation, and Mr. Watts testified, I had that conversation, I just don't recall when exactly it was. If this court has no further questions, I'd ask that you affirm the court's order. Thanks.
Thank you, Mr. Ake.
Is Mr. Ake correct about those additional comments and statements that Mr. DeSeur made at the Spencer hearing?
I believe what he said is what the record reflects, yes. As to the issue of what was told to Dr. Mayer, I think what Mr. Watts says was that he definitely, the uncontroverted nature of his testimony was that he didn't tell Dr. Mayer about the contents of the form at any point in time. So that's
he didn't tell him, even in general terms, that the defendant was doing it.
Well, Dr. Mayer said he didn't receive a call at all, and then Mr. Watts saying that there was a discussion or a phone call to him.
And now, did he say... The record, right? I mean, it's reflected in the record at the time of the trial that Mr. Watts said he talked to Dr. Mayer.
At the trial, Mr. Watts told the court that he had talked to Dr. Mayer. Okay. That's correct. But just one last attempt to bring in, a lot of defendants would waive mitigation for a variety of reasons, not because they want to join the state in seeking their execution. They would waive mitigation. A lot of times they don't want to put their family through the testimony or having to call them to talk about childhood issues or whatnot, or whether they were abused or not abused, and that's a relatively common thing. But it's not a common thing for someone to sign a form saying that he is joining the state in seeking his own execution. And all the people that had experience in the criminal justice system who testified at the evidentiary hearing on this matter, Dr. D, Dr. Mayer, Mr. Bruno, and the rest all said it was a very unusual happening in the competency evaluation.
And we don't, is this the first case that you know of where a defendant has said, I've joined in the state seeking the death penalty?
Not the first case I've ever heard of, no, where that occurs. Unless there's any other questions, I'll conclude my rebuttal.
All right. Thank you both for your arguments here today. The court will now take its morning recess for 10 minutes.
case on our calendar this morning is Boland versus State of Florida. Justice Quince is recused in this case and, of course, naturally would not participate. Justice Pariente had an emergency. She will participate, although not sit in on oral arguments. She will view those through gavel to gavel and participate in the decision. So with that, we're ready to proceed.
May it please the Court. Thank you for the explanation. I don't quite feel so outnumbered or possibly wondering if I did something during the break.
Take no offense.
It's fine. May it please the Court, my name is Andrea Norgard. I am representing Mr. Boland in this appeal from the denial of his motion for post-conviction relief pursuant to 3.851. There are two issues that were raised in the brief, and it would be my intent to address both of them in the order in which they were briefed. And the first issue addressed whether or not Mr. Boland's trial attorney was ineffective in failing to object or otherwise prevent a witness for the state by the name of Danny Ferns from offering an opinion that a substance that he observed on the ground within a short time of when this crime was alleged to have occurred was blood or not. And the position that was taken during the evidentiary hearing and on appeal is that a lay witness, such as Mr. Ferns, at the time when Mr. Ferns made his observations, he was 13 years old. At the time he first testified in the trial that is the subject of these proceedings, he was at that time 26 years old. And Mr. Ferns testified that he, as a 13-year-old boy, still in elementary school, had gone to the bus stop where he met another young man by the name of Philip Boland, who was actually Mr. Boland's half-brother. And Philip Boland appeared upset and told him some things that led them to return to this piece of property off Valencia Drive where there were some mobile homes, some camper trailers, and that while they were there, he observed on the ground a wet red substance, and he testified that he absolutely knew that this substance was blood. He offered the description. He did offer some descriptive terms as to why he reached that opinion, but he unequivocally stated when asked by the prosecutor that this was blood, and he was absolutely sure of that fact. Where Mr. Ferns' testimony was so critical in this trial was in the manner in which it buttressed the testimony of Philip Boland. Philip Boland has been a problematic witness for both the defense and the state throughout the three trials that this case has undergone. Philip Boland has testified, recanted, and given many differing statements about his observations that night.
But this was supposedly the scene where Philip had testified that he saw the body and the beating and then the hose and all those things. Was this the trial in which that was the testimony?
Correct. Philip Boland testified at that trial, in the trial in 2001. He did not testify to actually physically seeing the body. What he said was he saw something wrapped in a sheet that he then observed Mr. Boland use something that he really could not identify to strike this thing wrapped in a sheet. He heard some sounds. It sounded like he said a pillow being hit and some moans. And then he said he assisted in lifting the sheet-wrapped body into the back of a tow truck.
He heard the person what was being beaten moan.
He said that was in one of his statements. Quite honestly, Judge Labrigada, Mr. Philip Boland has given so many different versions of what he heard. I'm not sure if that was his direct testimony in this trial or the subject of other statements he'd made in the past.
The testimony was that he opened the trunk and he noticed something wrapped in a hospital-type bed or sheet or something like that. And the person, and what was in there was moaning, and that's when your client took out a stick with a metal point at the end and started beating the body, I guess to finish it off.
Well, I believe that Philip Boland's testimony, he did not identify the sheet as being a hospital sheet. He said it was wrapped in white material. I don't believe he said it was a hospital sheet.
Well, regardless of what he said, the point is that his testimony was that he heard a person moaning and that his stepbrother then took out his stick and beat the person until there was no moaning anymore.
Correct. That was Philip Boland's testimony. But I do think the court should note that Philip Boland had also at previous times recanted the testimony and claimed that he did not see the things that he testified at trial that he claimed to have seen. He's gone back and forth on at least 5 different occasions of whether he actually observed this or did not. So clearly Philip Bolin was a witness whose credibility was clearly at issue. So what you have to look at in assessing whether or not the admission of this opinion testimony that is clearly improper. I mean, there is no, I don't believe, any rule of law, dicta, holding, or otherwise from this court that would support Philip Bolin being able to testify as an expert witness.
Well, that's not really the issue. The issue is whether a lay witness can testify as to this particular matter. We know that he's not an expert.
Correct.
So then the examination or the analysis has to be what can a lay witness under these circumstances testify to.
And this court, correct, and this court, again, there is absolutely, in my opinion, no question that he could not offer that expert opinion testimony, or that he could not offer lay opinion testimony that what he saw was absolutely blood. Over 100 years ago.
I thought the question on the record was, did it appear to be blood? He said absolutely.
He also, though, repeated several times, was there any doubt in your mind it was blood? No, there wasn't. But again,
appeared to be blood.
Well, the question was...
But that's a statement about his perception. And this is, at the time, a 13-year-old young man testifying, right?
No, he was 13 at the time he made his observation.
Okay,
he was 26 at the time of testimony.
Okay, he's 26 at the time of the testimony, 13 when he observed it. The jury, however, is going to understand that he did not do a chemical test on the substance. I mean, they're going to understand that this is a person who saw something and based on common human experience was fully convinced that that was blood, without any sort of scientific test to verify that. The jury would obviously understand that, correct?
Well, however, though, that is not the sole criteria for deciding whether or not Mr. Ferns had the ability to testify in the manner that he did. This court has made it clear, and again, the last issued opinion that I could find from this court on this very issue was in 1898, where the identical issue was before the court about whether a lay person could state that a substance they saw was blood. And the court said, no, they can't. They can describe it.
90.701 of the evidence, though,
correct,
allows a lay person to testify about what he or she perceives in form of an inference or an opinion. Now, we have allowed people to testify as to how fast somebody's going in a car. How fast was he going? Well, he must have been going over 50, over 60, over 70. We have allowed people to testify as to whether somebody's odor of alcohol emanating from someone's mouth was alcohol. Didn't have to go do a test to see if it was really alcohol. There are certain things that are so blatant, so obvious that a layperson can come to a conclusion on. All this young man testified to was that when he was taken to the scene that morning by his classmate, what he saw appeared to be blood. Are you sure? Absolutely, it appeared to be blood. Why can't a layperson testify to something that looks like blood?
Because in Gantling, this court specifically said that they can't give that next step opinion. And I believe Mr. Ferns' statement that he absolutely saw blood takes it beyond it just appeared to me to be blood. And it's very clear that, for example, and again, I focused on the issue at hand, which was a testimony about a substance which you cannot immediately identify without subsequent testing. As this court has pointed out in other opinions, what an expert does in these type of situations is you have to do a confirmatory test. We have, in thousands of cases throughout the state of Florida every year, we have crime scene technicians and detectives and lab analysis who are presented as experts who testify that based on the testing that they do, that's when you can confirm what this type of substance is.
Well, in certain cases, whatever it is might be an element of the crime, right? For example, possession of drugs or something of that
But no, it is not the situation in this case. However, that was a critical piece of evidence because by the time Mr. Ferns testified, there was no opportunity to do any type of testing. And to go back to, I believe it was Judge Labarga's analogy about vehicle speeding or something like that, that would be something that a person could testify as a lay witness what they observed, but they could not conclusively state, it is my opinion that they were traveling at the speed up. That is simply something beyond the ken, to quote the language from the decisional authority of the state of Florida, it's beyond the ken of an average person's understanding. The problem in this case is that Danny Ferns' testimony was so important in terms of corroboration.
Well, but doesn't all this, assuming that there is accuracy in what you're saying, he was going to be able to testify to what? Could he testify that it appeared to him to be blood and just leave it at that?
Well, what he would have been able to testify to under Gantling, that he could describe what he saw. In other words, he could say it was red, it appeared wet, it appeared this big. But that was where he would have to stop.
But doesn't Gantling really deal with it? What the court was doing in Gantling was approving testimony that come in. They weren't saying something came in that shouldn't have come in. I think you're really stretching Gantling a little bit there beyond the actual holding in that case. So is your position that he could not say, well, it looked like to me it was blood?
He could have said, I thought it was, or it appeared to be, but he could not say it was absolutely.
If he could say that, in the whole context here, how is that really, I mean, that was what was going to come in, even under your theory. So it seems to me that the impact of this is going to be very minor because the jury is going to understand anyway that that's just his opinion about what he saw and that it's not a scientifically verified fact.
But the fact of what it was crucial to the case, which plays into the second issue, which was there was testimony that could have been presented to have explained that this was not necessarily blood, but in fact could have been red spray paint under the timeline that equipment had been being painted in that area in which a time period red paint was being used. So if you look at the two issues together, what you have is a statement from a witness who is he is the most credible eyewitness to anything that occurred, simply because from the date when these offenses actually occurred until the first trial, a period of 6 years elapsed. There was absolutely no way for defense counsel to have gone back and done anything because there was no crime scene evidence collected. I mean, this was nobody.
Didn't the grandmother testify that the father works in the carnival, has carnival equipment, and he had spray painted the carnival equipment in that particular case?
No, she did not. That is a mistake of fact in the trial judge's order. Gertrude Boland only testified that hoses were removed. Nowhere in her trial testimony in the defense case on the guilt phase did she testify about spray painting. She only testified about the removal of hoses. In the post-conviction hearing, Mr. Boland Sr. testified that he did the painting and he was the one who also removed the hoses. But at the trial, whether or not there had been painting in that area or not was never evidenced before the jury.
Justice Perry has a question.
Well,
I'm so sorry.
It was answered. I had the same question Justice Kennedy had. That you're suggesting that a 13-year-old has to be a blood expert to testify that what he saw appeared to be blood. You aren't saying that, are you? And surely, if you're saying that, the jury, by this mere observation, could see that he was a 13-year-old. He probably had some knowledge of blood, of what blood looked like, but he certainly wasn't testifying as an expert that the fact that it was blood, but it appeared to be blood.
I disagree that on the appeared. I believe that by the content of his response, that absolutely he was certain that it was blood. The response went further than the question. If he had said, yes, I think it was, that would be a different response than absolutely, I saw blood. I believed I saw blood. He was not equivocal in any manner in his responses about what the substance was. And there is a distinction. The evidence code makes a distinction. That's why a crime scene technician who certainly has more experience and would fall closer into the category of an expert witness than Mr. Ferns would, does not testify that they saw blood at the scene. They testify that they saw apparent blood, and then the serologist or the lab person who does the confirmatory testing comes in and testifies, did you receive, as part of the evidence in this case, a substance that appeared to be blood? Yes, I did. What did you do with that substance? I performed this test, and this test. And can you state in your expert opinion what the result of those tests was? Yes, I can confirm this was blood. That is the evidentiary procedure that the evidence code requires when you are dealing with a substance that requires expert testimony for identification. I mean, clearly, and if we recognize that for individuals such as crime scene technicians and experienced police officers, the same rule of law ought to apply to 13-year-old kids, and it wasn't used in this case. When you combine that with the fact that there was a failure to then present the evidence of Oscar Boland Sr., which offered an alternative explanation as to what this red substance on the ground was, then you have the prejudicial error.
So, well, now you're saying that the trial judge made a mistake when he put in his order that this evidence was submitted by Trudy, the stepmother, that in fact Oscar Sr. had spray painted some carnival equipment 3 or 4 weeks prior in different colors other than red paint in the grass.
Oscar Boland Sr. testified at trial in 1996.
No, I'm talking about you saying the trial judge made a mistake when he put that in his order.
Yes, he did. Oscar Boland Sr. did not testify at all in the 2001 trial.
Trudy,
right. And Trudy did not address painting in the 2001 trial. In the 96 trial, Oscar Boland Sr. did testify about painting. In 2001, he does not testify at all. Trudy testifies instead of Boland Sr., but Trudy does not address painting. She only addresses hoses being removed. She does not talk about what her husband did or didn't do regarding painting.
You're well into your rebuttal.
I know.
Do you want to touch on a second issue before you...
I'll do that in response to Mr. Ake's arguments.
Well, let's do it now if you're going to argue another point, so he has an opportunity to address it then.
We're good at this point.
Okay.
May it please the Court, Stephen Ake for the State of Florida. We're here on a denial of a claim of ineffective assistance of counsel, and I haven't heard any testimony as to what counsel testified to at the evidentiary hearing, and I think that's very important in analyzing this issue. Is the attorney, John Schwisher, that was representing Mr. Boland, testified that he had read the previous trial where counsel had objected to this blood testimony and it had been overruled. So we also supplemented that in the record, and that's part of the record. But the question at trial to Mr. Ferns was, did this appear to be blood? And his answer was, no doubt, I knew it was. He had testified that he knew what color blood was. He had seen it before, prior to this observation, and the prosecutor asked him 2 questions about whether it appeared to be blood, and the answers were absolutely, no doubt, I knew it was. Counsel testified he didn't recall a specific reason for not objecting to that, but that he had read the previous record where that objection had been made and had been overruled. And trial counsel also testified that he knew it was common practice in that circuit for judges to allow lay witnesses to testify to their observations as something was indeed blood. So I think when you look at this, you have to analyze it under an ineffective assistance of counsel claim, as opposed to what counsel is really trying to argue is almost more like a direct appeal issue as to whether or not a lay witness can testify to this. Is you have to analyze it under the ineffective assistance of counsel and whether trial attorney performed efficiently and whether there was any prejudice. And as the trial court did in his order, obviously there's no prejudice in this case, because even if Mr. Swisher had objected or anything, it would have been clarified that this was a 13-year-old boy. He didn't perform any scientific testing on this. This was just based on his common experience and knowledge of blood, and that it appeared to be blood. That's what would have came out of it. And counsel talks about how critical Danny Ferns was, and I would contest that also, and note that this court on the appeal in this case, when analyzing the sufficiency of the evidence, never even discusses Danny Ferns' testimony at all. He's not even mentioned in the opinion in that regard. So granted, he did corroborate Philip Boland's testimony, but it was certainly not key to the state's case. As the court noted, Philip Boland...
Going back to the opinion testimony for a second, I mean, you do realize that if we agree with you, that there will be a Supreme Court opinion saying that a layperson can identify blood on a garment, on a rug.
There already is, Your Honor. In Floyd versus State, which is cited in her brief, this court says...
That's 1990.
Excuse me?
Floyd versus State, 1990.
1990, right. Yes. In that case, dealt with a law enforcement officer testifying as to blood on an object, and this court specifically said that that's within the permissible range of late observation, that an item was blood on a tissue box, I believe it was. So this court has indeed said that. I don't think lay witnesses have a problem identifying a substance as blood in a given circumstance. So I don't think you can make any kind of bright line rule as to when they can testify. If somebody sees somebody get shot or stabbed and sees them bleeding, obviously they're going to be able to testify that that's blood. If they see them leave a puddle of blood on the ground, they're going to be able to say, yeah, they saw a puddle of blood. And so I don't see any problem with a lay witness under 90.7001 testifying that it's their opinion that the substance appeared to be blood. The second issue dealt with the quote-unquote alternative explanation for what this substance was from Oscar Ray Boland Sr. And again, this is an ineffective assistance of counsel claim, and the trial attorney testified at length at the evidentiary hearing as to why he did not call Oscar Ray Boland Sr. to testify about the spray paint. He gave 5 reasons as to why he didn't do this, and I submit that those are all supported by the evidence in this case. Now, I will note that the post-conviction court did make an error in his order, in that he said that Gertrude Boland had testified as to the spray paint, and that did not take place. Gertrude Boland testified as to the hoses, and as the trial attorney mentioned at the evidentiary hearing, the state, in closing argument, made light of that, and the jury was laughing about Gertrude Boland's testimony, and that was basically his reasoning for not calling Oscar Ray Boland Sr. was that he was a father, a biased witness, obviously, and that he was not a good witness. The trial attorney had conferred with him and found that he was not credible, and also had talked to both Oscar Ray Boland and Rosa Lee Boland, and they had both jointly made that decision also that he would not be a good witness. Those were a couple of the reasons that counsel gave as to why he did not present Oscar Ray Boland Sr. And I would submit that those reasons, as the trial court found, were a tactical decision that are not subject to attack in this case. If there are no further questions, I'll ask this court to affirm. Thank you.
Rebuttal.
In responding to the state's position on the second issue, that the reasons that Mr. Swisher gave and the trial judge identified, I believe there were 4, in his order for not calling Mr. Boland. If the court looks closely at Mr. Swisher's testimony, and as was pointed out in both the initial and reply briefs, every reason that Mr. Swisher gave, he disregarded his own reasoning at some point in the case. For example, he testified quite clearly during the evidentiary hearing that he did not ever recall talking to Mr. Boland Sr. about the painting. He only talked to them about penalty phase, and the decision was made not to call any family members at all because we want to save them for penalty phase. But he still called Gertrude. Then Mr. Swisher offered up as an explanation for not calling Oscar Sr. was the fact that they weren't good witnesses, and they were hillbillies, they were from the holler, they wouldn't come across well. But again, he called Gertrude to testify. The conversation that Mr. Swisher acknowledged occurred about whether or not Mr. and Mrs. Boland, the parents, would be good witnesses or not, was strictly directed at penalty phase. I think the record is amply clear that Mr. Swisher's explanations and excuses for why he didn't use Oscar Sr. in the guilt phase in this trial were simply thought up as an after-the-fact justification for why he didn't do what he needed to do the first time around.
What about the fact that he
Well, again, what the timeline that we're looking at is that Mr. Boland spray painted and then left the state. There was no suggestion that falls into the explanation. If the spray painting had occurred after the homicide happened, in other words, if Mr. Boland had testified, I didn't leave until Christmas, obviously his testimony would have been of no value. For Mr. Boland's testimony to have merit, he had to have done the painting before the crime, and that's what he testified he did. I mean, you know, quite honestly, I've got spray paint all over my yard right now from the utility company that's been there for a month despite all the rain. I mean, paint can last on grass longer than a couple days. Mr. Boland's testimony was essentially, I did this a week to two before this happened because we were gone. The homicide happened allegedly on December 5th. That was the date that the state used in the indictment. Mr. Boland testified in 1996, we left shortly before Thanksgiving. I believe that Thanksgiving is generally the third Thursday of November. It's the only holiday that's specific, doesn't change year by year in terms of when it occurs. So clearly, he did this beforehand. There was an explanation that contradicted Danny Fern's testimony about what that substance was.
And with that, if you'll bring your argument to a conclusion, you're beyond your time.
Your Honor, what we would ask the court to do in this case is to reverse the order of the trial court and to order a new trial for Mr. Boland. Thank you very much.
Mr. Norgard, Mr. Egg, thank you very much for your help on this case. The court will take this case under advisement. Court stands in recess. Please rise.
You're watching the Florida Channel, a public service of the Florida Legislature, WFSU-TV, and Florida State University.